Welcome to our legal translation course. In this opportunity, I have found interesting if we could give this chat in English, basically because we are going to deal with the Venezuelan criminal court process. And in this fashion, it will be easier for you maybe to catch some vocabulary that will be of use in the English language. Due to Spanish and French influence, Venezuela has a civil legal system. That means we have a civil law system where the law is written in laws and codes, and court decisions do not create precedent. The only exception that we can make in this connection is that some decisions of the Supreme Court actually can create some precedent, and they are binding upon citizens and upon institutions in Venezuela. In 1999, however, the traditional civil law criminal system was replaced by the adversarial system. So when you got, oral trials where we got jurors and we got, in some cases, also the judges, and we will be talking about that when we come to that point. I would like to begin by talking about the defendant's rights. Why? Because the defendant's rights in a system, in a country, tells you a lot about how the legal system works. The Constitution and the Criminal Procedural Code of Venezuela include the rights of the defendants. They are complemented by the American or Inter-American Convention on Human Rights and the International Covenant on Civil and Political Rights. Both are binding upon Venezuela. Consequently, the rights of the defendant are according to international standards, including, among others, the presumption of innocence, la presunción de inocencia, equality before the law, la igualdad ante la ley, due process, el debido proceso, the right to remain silent, el derecho a permanecer callado, and the right to counsel, y el derecho a recibir asesoría legal. Well, the criminal process in Venezuela begins at a pre-trial phase, where the prosecution office, a prosecutor, fiscal, is the entity empowered to initiate the criminal prosecution. The prosecution office has the responsibility of investigating the alleged crime, and it is obliged, or it is bound, to communicate any evidence that may benefit the alleged responsible person. The pretrial judge, juez de control, or the pretrial court, tribunal de control, has to ensure the compliance with due process. The pretrial judge may decide to dismiss the case or to formalize the accusation, to file charges against the person or the defendant. During the pretrial phase, detention is possible in Venezuela. According to the law, this is an extreme measure and should last no longer than 2 years. Nonetheless, in most cases, or in many cases, a pretrial detention order can be issued very easily, and the 2-year condition is oftentimes not enforced due to the delay of the proceedings. Well, then, after the pretrial phase is over, when a judge has either dismissed the case or accepted the case, there will be two things to happen. The dismissal means that the person who has been arrested, or who has been submitted to investigation, is liberated, is released from charges. If cause is found, then the case is accepted and is submitted to trial or committed to trial. With the implementation of the adversarial system, the criminal proceedings became oral, as I explained before. The defendant must be normally present. In case the defendant does not wish to be present, then he or she may request a special permission to leave the courtroom. In any case, the defendant may communicate with his lawyer at any time. The defendant has the right to present documentary evidence, as well as witnesses and expert witnesses. Cross-examination is also allowed in the Venezuelan system under that implementation of the new organic criminal procedure code that happened or that occurred in 1999. Both in the trial phase, both the defendant and the prosecutor may appeal the decision. After the Court of Appeals decision, there is the possibility to ask for cassation. Cassation means to file a remedy with the Supreme Court in order to review matters of law in connection with the case that where any of the parties might not be so satisfied. Well, for example, in cases of crimes which punishment is longer than 4 years in prison, the defendant has the right to file, an appeal with the Supreme Court, a cassation remedy they call it, where only matters of law are discussed, not the facts. There is also the possibility of revision on extreme cases, for cases that have already been fully decided. For example, when a person has been condemned 2 times for the same crime, or when the principal evidence for conviction is proven as fake. Well, now I would like to explain a little bit how does the judiciary works in Venezuela. The judiciary is the judicial branch of government in Venezuela, which is a country that has 5 branches of government, unlike most countries that have 3 branches of government, 3 powers. Well, the Supreme Court of Justice, Tribunal Supremo de Justicia, is at the apex of the Venezuelan court system. It has 32 justices, magistrados or magistrates, who are elected by the National Assembly for a single 12-year term. Appointments are made following recommendations from the Committee for Judicial Postulations, which consults with organizations dealing with legal issues and with the bodies of the citizen power, which is another branch of government in Venezuela, the citizen branch of government. The Supreme Court is the court of last resort, the último recurso, and may meet either in plenary sessions or in groups, forming specialized chambers or divisions, what we call in Spanish of Venezuela, salas del Tribunal Supremo. These chambers or divisions are 6. We got the constitutional, the political administrative, the electoral, the civil appeals, the criminal appeals, and the social, which is mainly agrarian and labor, issues appeals. Those are the divisions of the Supreme Court of Justice in Venezuela. The Supreme Court is empowered to invalidate any laws, regulations, or other acts of the governmental branches conflicting with the Constitution. It also hears accusations against high public officials, cases involving diplomatic agents, and certain civil actions arising between the state and the individuals. The lower court, Tribunales de Primera Instancia, includes district and municipal courts, as well as trial and appeal courts that deal with civil and criminal matters. The lower court system is somewhat complex. There are courts with special jurisdiction in the following areas: civil, commercial, criminal, labor, tax, custom, administrative, juvenile, military, and agrarian matters. In these jurisdictions, to varying degrees, courts are placed in a hierarchical order, are arranged hierarchically, and they are competent on the basis of the amount involved or the importance of the case. What I mean when I say the amount involved, that is the case of lawsuits involving amounts of money, sums of money. For civil and commercial cases, for example, they are divided as follows. The lower courts are divided as follows. We got parish courts, we got district courts, courts of first instance or lower courts as well, superior or appeal courts. The appeal courts are called in Spanish of Venezuela tribunales superiores. As a rule, judicial decisions may be appealed to a higher tribunal, to a higher court, but cases may not be heard in such courts more than twice. a case most of times are not heard but in two courts, in a lower court and then in a superior or appellate court, which is another name that is given in English for the superior tribunals or superior courts. Let me say a few words about the latest innovations in the criminal procedure in Venezuela. The introduction of a Justice of the Peace network is one of the innovations that we could we can refer to lately. And there was also a reform or an amendment to the criminal procedure scheme. The creation of the network of justices of the peace is to try to change the way of bringing about the resolution of conflicts and controversies arising in local communities by means of mediation. That means that justices of peace are used as mediators in controversies that have arisen or that have arisen in the communities, in local communities. They sometimes can use equity when the parties specifically requested, or under certain circumstances where the law provides that equity can be used. Well, the other change or the other innovation that has occurred in terms of the criminal procedure scheme entails the establishment of a new accusatorial system where we got active parties contesting with each other, or what is known as an adversary system. And this substitutes the traditional inquisitorial system, and resulting in many manners in the underscoring of the role that is played by the judge as the decision maker throughout the trial, where the judge becomes the person who will preserve the abidance by the law, but where we will have some other actors deciding, about the nature of the case and about the situation of the defendant, whether he or she is guilty or not guilty. In this connection, we got with the new reform or with the new amendment to the Criminal Procedure Code, we got people participating, citizens participating as lay judges, escabinos, lay judges, and as jurors, jurados. But there are other actors in the judicial system. Particularly important is the Office of the Prosecutor General, Fiscalía General de la República. This office, the prosecutor's office, is in charge of public prosecutions. It is an autonomous and hierarchical organization. It belongs neither to the executive branch nor to the judicial branch of government. The 1999 Constitution confers upon the Office of the Prosecutor General an independent role so that it can be better in the execution of its functions and in the performance of its role as guardian of constitutional rights and liberties. Also, the Office of the Prosecutor General must watch over the application of democratic principles, also is in charge of the public interest and the rule of law in general. He's the guardian of those important democratic institutions. The head of the Prosecutor General office is the Prosecutor General of the Republic, Fiscal General, who is designated for a 7-year term and is in charge mainly of prosecuting crimes and representing the people's interests in those cases in which no initiative on the part of a party is required, donde no hay acciones a instancia de parte. The Prosecutor General shall also file any appropriate action to hold liable those public officials, those civil servants who have incurred in civil, labor, military, criminal, administrative, or disciplinary liability in the course of their official duties or in the course of their tenures. We also have, as a participant in the judicial system, also particularly in the criminal procedure as well, the Office of the Defender of the People, or the People's Attorney, also known in many countries as General Ombudsperson, Defensoría del Pueblo in Spanish. This entity is an independent body that has been created within the sphere of the National Assembly and operates independently, receiving instruction from any authorities without receiving instruction from any authority. I mean, it may take cases against the government either on its own initiative or at the request of any third party. The services that the public defendant, the public defender or the defender of the people is or renders are free of charge. The defender of the people is appointed and may be removed for cause by the National Assembly with the vote of 2/3 of its members and shall hold office for a single 7-year term. The mission of the ombudsperson or the people's attorney or the people's defender is the defense and protection of human rights and other liberties and interests protected under the Constitution and the laws in the face of deeds, acts, or omissions of the administration. Without a direct participation, it is important to mention that the activity or the role played by the Ministry of Justice and Internal Affairs, which in Venezuela the official name in English will be the People's Power Ministry for Justice, for Interior, Justice and Peace. This ministry oversees the prison system and manages the Bolivarian Service of National Intelligence, SEBIN in Venezuela, which is the body engaged, in the all national intelligence issues. And also, we got the body which is in charge of the scientific investigation of crimes, which is the Cuerpo de Investigaciones Científicas Penales y Criminalísticas, also known as CICPC, and which stands for Scientific and Criminalistic Investigation Bureau. And last but not least, we got the Executive Office of the Magistracy, or Dirección Ejecutiva de la Magistratura, also known by its initials DEM. The Executive Office of the Magistracy supervises all lower courts, as well as the selection and training of judges. Well, this has been a general overview of how the court process is in Venezuela and of the various actors that play a role in that process.